Joining me now, it is a pleasure to welcome back to the program a columnist for The Guardian and as well as a best-selling author, Glenn Greenwald. Glenn, welcome back.
Great to be back, Sam.
So over the past couple of weeks now, we have seen it has come to light, something that you have been warning people since, this goes back to the Bush administration in some respects as well, but warning people particularly since the beginning of the prosecution of Wikileaks. And that is that the Obama administration has begun to set precedents where it is not simply attacking leaks in its own administration. It is in many respects criminalizing the news gathering process. Let's just start with the AP revelations and what that indicates. And of course, it goes further with this latest revelation about a Fox News reporter, Rosen. But let's start with the AP.
Right. I actually think the revelation yesterday about the Fox reporter is a huge escalation beyond even what the AP was. But the AP controversy is very significant in itself because it was a massive invasion on the part of the Justice Department into the communications that AP journalists and editors had with a variety of people over the course of weeks. It turned out that they obtained the phone records for multiple AP bureaus, as well as it turns out, we learned yesterday, the home phone, and cell phones of those journalists and editors as well, which means that they were able to learn the identity of every person with whom those AP journalists communicated by telephone during that period of time. Now, what made this so disturbing is that it is the case that in a leak investigation, the Justice Department has the power, the legal authority, to obtain the phone records of people that they think might reveal the identity of the leakers. But when it comes to doing that with regard to journalists, there's a whole variety of rules in place because of how threatening to press freedoms that kind of invasiveness is, one of which is that in almost every case, the Justice Department is supposed to notify the media outlet in advance that it is seeking these phone records, because that would then enable the journalist to either negotiate a narrower, more reasonable way to get these records, or to go into court and ask a judge to rule on whether or not the attempt is legal and proper. And in this case, the Justice Department didn't tell AP until after it had obtained these phone records that it was doing so, depriving them of the opportunity to do anything about it. Just went and secretly got all of the phone records for all these AP journalists. And the reason that's so damaging is because journalists rely on the ability to speak to sources confidentially without the government knowing about it in order to gather news. That's how every investigative journalist for the last many decades has reported on what the government is doing. And if the government can now just invade that process and learn the identity of the people with whom journalists are speaking, it makes the job of journalists impossible.
Now, we should be clear here. What the Justice Department in the case of the AP was subpoena these records. They didn't read the emails. They simply subpoenaed the records. And as you say, they did it in secret when generally it's done with the opportunity of some form of judicial review, unless they can come out with a negotiated settlement with the media agency. So in many respects, you could also perceive what the Justice Department did here in the AP case was explicitly and specifically to avoid any type of judicial review of this investigation. And it raises certain questions as to why they wouldn't want some type of judicial review. The other aspect of the AP records is how broad of a period of time and how many phones that they covered. This also, at the very least, brushes up against their guidelines. I mean, in this instance, because there's no judicial review, they're completely they have complete autonomy in determining whether or not they have violated their own guidelines, which is also problematic.
Right. I mean, here's how judicial proceedings typically work. Is if you are in a civil lawsuit with another party, or if you're involved in a criminal proceeding with the government, if one side wants to obtain records from a third party, it issues a subpoena, and at the same time, it sends notice of that subpoena to the other side so that if the subpoena is objectionable or legally baseless, that party can run into court and ask a judge to quash the subpoena and to say you should either limit it or quash it entirely because there's no legal basis for it, it's too intrusive, those kind of things. In the Justice Department's guidelines, it does say that the normal course of action when you're subpoenaing records of a media outlet should be to go to the journalistic entity ahead of time to give them that opportunity, and the only exception is where the integrity of the investigation would be jeopardized if you give advance notice. And what that normally means is if you tell a media outlet in advance that you're trying to get certain records, and telling them ahead of time would enable them to destroy that evidence, that would then jeopardize the integrity of the investigation and justify your doing it without telling them. In this case, that doesn't even remotely apply because the records weren't in the possession of the AP. They were in the possession of their telephone carriers, Verizon and AT&T. So AP, even if there was some danger that they were going to destroy the records once they found out the Justice Department was pursuing them, wouldn't have even had the physical capability to do that. It would have remained exactly where it was. Those records weren't going anywhere. There was no reason to avoid telling AP other than a desire on the part of the Justice Department to avoid having a judge rule on whether this sweeping, invasive, quite threatening request was legally proper or not. And the other point I just want to make is this idea of these guidelines that the Justice Department has adopted. Over the past several decades, there have been lots of debates in Washington about whether laws need to be enacted to protect journalists from these kinds of actions on the part of the government. And what the government has always said is, look, you don't need a separate law to protect journalists because we have all these really restrictive guidelines that we follow that if we ever want to get the records of journalists, the phone records or the email records, we have all these really great restrictions in place. The Attorney General himself has to sign off on it. Our policy is to tell them in advance so that they can go into court, except in the rarest of cases. We only do it as an absolute last resort if there's no other way to get this information. So these guidelines are what the Justice Department has always pointed to as a way of telling Congress you don't need to pass laws protecting journalists. So when the Justice Department goes and violates their own guidelines in the way that they did in this case, it's really quite a serious thing.
And we should also say that back in 2009, when a media shield law was being proposed in the Senate, the Obama administration specifically pressured the senators who were raising this issue to water it down significantly, really to the point of it having no efficacy. Again, to allow the Justice Department to have almost total autonomy in making the determinations as to whether or not what they're doing is appropriate, and removing that authority specifically in at least this is the reporting that Charlie Savage did, removing the authority of judges to weigh in on whether or not the Justice Department requests are legitimate on national security grounds. And so, you know, we should make this clear because it is at the very least indicative of the Obama administration's position on this from the very beginning of their administration. Right.
I mean, it was interesting because when this AP controversy erupted, the instinct of a lot of progressive commentators, sort of MSNBC types, is in every single case to figure out how to blame Republicans. So they had kind of a dilemma, which was, well, here's something that the Obama Justice Department did, not because anyone passed a law forcing them to do it, but because they simply chose on their own to do it. How can we blame Republicans for this? And the solution that they came up with was to say, well, look, the Republicans filibustered and blocked the enactment of a law in 2007 that Obama favored when he was in the Senate that would have protected journalists. It was true, that claim, only to a very limited extent because that law that they blocked probably wouldn't have provided much protection for AP in this specific case. It's also a really bizarre thing to try and blame Republicans for blocking a law that would have given journalists protection from the Obama administration. I mean, even though journalists don't have the statutory protection, nothing forces the Obama administration to go and invade the news gathering process this way. But what really made it a kind of misleading argument was that although it is true that Obama, when he was in the Senate, favored laws that would have protected journalists from these kind of government intrusions, once he became president, he basically reversed his position and started opposing these kind of laws unless they were watered down to the point of meaninglessness by including the national security exemption that you just described. And the reason that law didn't get enacted, according to lots of press freedom advocates and transparency advocates and people who have been advocating for these kind of laws for a long time, is precisely because of the actions of the White House, not the Republicans. And but at the end of the day, although the Justice Department shouldn't be, and there's no evidence that in this case they were, taking immediate direction from the White House, it is the Justice Department that's making this choice to invade and target journalists this way. And I think the key point here is that it is all part of this broader climate that President Obama has established, as you said, from the start, which is to be more aggressive with safeguarding secrecy and attacking whistleblowers than any administration in U.S. history, and any president in U.S. history. And the key stat to that is that the Obama administration has prosecuted double the number of whistleblowers under espionage statutes than all prior administrations combined.